everybody. Welcome back to Men Need to Be Heard. It is Dan, and we're back with another show. We're going to be talking about a pretty tough topic today, which is false allegations, but more specifically, false allegations of domestic violence. It's one of the top things that I hear from men about, and to be honest, some women who have, been accused of things. It comes up in family court a lot. It comes up in other areas. And, when I'm coaching someone or trying to help them out, I can give them some advice, but I'm not an attorney and I don't even play one on TV. So I like to get them to someone that can help them. And as you also know, because I've talked about it on the show a few times, I, along with my co-author Lindsay, are writing a book on false allegations. And as part of the research that I was doing for that book, and believe it or not, Lindsay was doing a couple of weeks later, I ran across our Guest Today's YouTube channel. And it is honestly one of the best channels I've ever seen on this topic. And in fact, I've already started referring people to it. So let me bring my guest on. She is Veronica Barton. She is an attorney in California. I guess I'll just leave it there if you want to add more to it. Veronica, thank you for coming on the show and welcome.
Thank you so much for having me.
So tough topic, and we're going to get into some various things. But before we do, why don't you tell us a little bit about yourself and what you do?
Sure. So again, I do practice in California. I'm only licensed in California, and none of this is legal advice as a disclaimer. And I primarily work on domestic violence cases. So that includes criminal defense. And I used to do a lot more criminal defense. I've tried first-degree murder cases at jury trial. And I also do restraining orders, which is more family law than criminal defense. I would say it's sort of quasi-criminal in nature. But I help people who have been arrested for domestic violence or people who have been served with a restraining order and have a hearing.
And as I said, she covers this on her website. You also have a course that we're going to talk a little bit about down the road here on the show, because I think it's something that people who, God forbid, ever have to face something like this could really benefit from. I guess, Veronica, the first question I have is there's a lot of confusion from my followers and listeners about what actually constitutes domestic violence. I think most people know the physical side of it. I don't know if you're aware of this, but I am a former trained peer counselor for domestic violence victims. I ran a men's group for about 3 years. So I know what it is. But the average person, they kind of define it as the physical and stop there. But in reality, it's much more than that. Can you kind of share some thoughts and the legal side of that?
Right. So there's actually very good reason for this confusion. In fact, I was on a court website yesterday, I think for Fresno, and I saw that they actually had some incorrect information on there. For criminal law, domestic violence, there does have to be some sort of physical violence. There has to be some sort of unwanted touching. It can be a shove without injury. But for restraining orders, it can be harassing someone or disturbing someone's peace, which is as vague as it sounds. It can be somebody blocks you. And so, blocks your phone number. So you get another number or you send them multiple WhatsApp messages. It is really vague and it is difficult to, it's such a gray area that it's difficult to give you a list of like, hey, if you do these things, a judge will find that that's domestic violence and these other things are okay.
Yeah, it's like you said, it's very vaguely written. I guess that some of the ways that's to give the judges some leeway and discretion, which isn't necessarily a bad thing. But it sometimes can go a little too far with that. I've talked about on the show before, if you ever want to I call them TROs, they're EPOs, they're TPOs. Every state's got a different word for what these are, temporary orders. But it's the 5 magic words. I am afraid of him. That's it. In the state of New York, where I'm originally from, that's all you need to say, and you'll get one. It's almost a slam dunk. And I don't. Again, we want to protect actual victims always, and I want to put that disclaimer out there. But the honest truth is, there's a lot of times these are not legitimate allegations, or it's mutual, but we're only seeing one side of it. And I guess where I want to go with that is, with all of your experience and having dealt with this, both criminally and I'm sure civilly as well, how prevalent is the false allegation thing? Because I'm hearing a lot of different things. And what I'm hearing from attorneys, and this is why I want to get your opinion, is especially family court attorneys, they're seeing it in 50 to 70% of the cases now, which is a pretty high. It's actually shocked me the first time I heard that. What is your opinion on that? What are you seeing?
So, how I first even started working on restraining orders in the first place, I wanted to just do criminal defense. I like being a trial lawyer. Didn't want to touch family law. It's when I first came to LA about 11 years ago, I was waiting for my bar exam results. I volunteered for the domestic violence clinic. They have them at courthouses. They're run by bar associations throughout the state of California, probably other states too. And, I thought, okay, I'm going to help victims of domestic violence, right? Nobody's pro domestic violence.
Right.
And so my job was I would interview people who wanted one of these temporary orders of protection, and get their story and try to make it sound as good as possible. And then a judge would usually just sign off on it with looking at it for a few seconds. And so I would hear people's reasons for wanting restraining orders. Okay, they want custody, not even because they want the kids, but because they want to get more child support. Or they were told by Child Protective Services that they have to get a restraining order, but they don't really want one. Or they want the apartment or the house, and they don't want the other person to live there. They want them to be kicked out. Eviction takes a long time, and they want the other person to still pay. And those would be their reasons. So, I volunteered there for a few months, and I was like, this is crazy. Of course, there are people who are legitimate victims of domestic violence, but there were so many people who had these ulterior motives. And I've spoken to family law attorneys, one of them who called this the domestic violence trick, filing a request for a restraining order, filing for a temporary order of protection, because it is a way to gain more leverage. Typically, custody is going to be about 50-50, depending on the circumstances in California. Okay, there are rules for, how is property going to be divided? Will there be alimony? Is there going to be child support? It is all basically down to a formula. But the way that you can get more leverage, you can get the kids for more, for example, is to file a request for restraining order. So I'm not sure if it is in 50 to 70% of cases, because I don't take family law cases and go through the whole divorce and child custody proceedings, but it is much more prevalent than I ever believed when I first started volunteering to help people do this.
Yeah, it's interesting, Veronica, because one, I applaud you for not doing family law because when I talk with the attorneys that do it, I don't know there's some very good ones, there's some bad ones, but I always believe that there's a lot of people doing, like you said, they come out of law school and they want to do the right thing and they get into various things and then they find out the realities. And anyone who can stick with family law for any length of time, I bow to them. But anyway, setting that aside, it's interesting because what you're talking about, we've covered on the show, it's called the silver bullet in many areas, right? Because it's a guaranteed slam dunk way pretty much of getting custody and, of course, child support afterward. And unfortunately, it puts the person that's accused, which, to be fair, it's primarily men, but honestly, it happens to women too. And I say it's not fair either way. The ones that get hurt the most in those cases are the children. And I absolutely believe that. But I guess what I want to go with that is, when they're getting these orders and, trying to use the silver bullet, how do you think the courts are viewing it now? Because I'm sensing that, I've been involved with helping people getting through divorces in family court for almost 30 years now. As, an advocate, as I said earlier, I was a peer counselor for domestic violence. I work with guys and coach them. I'm starting to get a sense that the courts are a little bit more aware of the realities that there is a number of false allegations. I don't want to put a number on it because, like you said, we don't really know. No one's ever actually studied it, I don't think. What's your sense of it? Is there, because the argument before was that it's a slam dunk, you're going to get it, and even if it's temporary, it's going to become permanent. That was 20 years ago. Where are we at with it now?
Well, I'm not sure about 20 years ago. I've only been doing this for 11 years.
Well, I'm a little older than you.
But I would say I do think that that is correct. I think that judges are a bit more suspicious of these restraining orders now. I mean, we're right though that, basically people might file these because they have nothing to lose, right? You have nothing to lose if you file a restraining order. Maybe you can get your attorney's fees maybe the other side can get their attorney's fees from you, maybe. But you can, especially in California and LA, the courts are really, really crowded. If you can get that temporary restraining order and you don't actually finish your hearing for sometimes like 6 months, then that entire time you have the kids, you have the house, and you lost nothing. So even if you ultimately do not get the longer restraining order, which could be up to 5 years, even if you don't get that, well, you got something. And now you are in the house, right? Maybe you're in the house, you have the kids, and now it's on the other side to try to change the status quo, which is going to be a lot more difficult for them.
And again, we're talking family law here, but the reality is it happens outside of family court as well. And we're starting to see more and more can't talk today. False allegations. Let me put my teeth back in various areas. Back in the day, I was in corporate IT. I actually ran several IT departments. So I was involved in allegations that were within the corporate world that were being investigated by human resources. Say they would call me in to do like forensics on the computers and stuff like that. So, I saw how those investigations were being conducted, and honestly, how easy it was for an accuser to convince anyone that the accused was guilty. Right? In the corporate world, there was very little evidence. Family court, generally, as I said before, I am afraid of him is all it takes. But I want to kind of go where your area of expertise is, which is, it includes family court, obviously, but in general, how easy is it really to get a TRO, an EPO, a TPO, whatever terminology you want to use? Is it really? Because if I'm wrong, I'd love to hear you tell me I'm wrong. I am afraid of him. Is it that easy?
Okay, not just I am afraid of him, but very close to that. So you do need to describe some sort of violence and it has to be somewhat recent so that the court can see that there is potential for future violence. There has to be something in there. And by violence, I do mean, again, this could be harassment. It would have to be something repeated. It could be a threat of violence. It could be, disturbing your peace. But you can probably in 5 minutes, I could write up with just a pen and they have a form you fill out. I could write that up. You could write that up. And it really doesn't take any legal knowledge and submit that to the court, and it would almost certainly be granted. The other side is actually supposed to get notice. They're supposed to get several days notice in the state of California, but there's also a court form that if you don't want to give notice, and this is routinely filled out by, nobody ever gives notice for them, basically. If you say, well, I didn't give them notice because I was afraid that the violence would reoccur, then the other side doesn't get a chance to give their side. So the first they hear about it, they are being served with this thing. So it's very, very easy to get. It doesn't take very long to fill out. Anybody really could fill it out. And there are people at the courthouses that will help you.
Mm-hmm. Yeah, well, it's funny. I have helped people fill them out, so I know exactly what you mean. In my case, though, I would never do it unless there was a legitimate reason, which unfortunately there's a lot of people that will do it with no reasons. But, you're kind of touching on ex parte proceedings, which was a question I was going to ask you about is, I know of situations, again, we're talking broadly here. You're in California. I'm not an attorney. We're just kind of giving information here. And I want to make sure people understand that state laws are different and all that stuff. So you need to talk to an attorney in your state or someone who knows what they're talking about. We're just talking generalities. But, where I was in New York helping guys, where I am now in North Carolina, it is a very simple form to fill out. And you can, in some cases, it's check a box that you don't want notification to go out. And then more often than not, the guys that I've helped, their attorney will go in. The guy doesn't even have to go in and ask for the TRO. And I know it works the opposite way, where the attorney just goes in. here, Your Honor, I have this form. Again, they say something like, I am afraid of him, or my client's afraid of him, or some variation thereof, and boom, it's done. And people don't, I think, Veronica, understand that it's that easy in times. That the way you do find out is the sheriff shows up at your house to evict you with that order, and you're blindsided. And, again, it goes back to what I want to ask you as an expert from the legal side is, everyone argues that, wait a minute, this can't happen. We have a judicial system, right, where you're allowed to defend yourself, but yet here you're not even in the courtroom. I know the answer, but I want my audience to hear the answer. How is that allowed?
Right. So, I mean, the idea when they structured the law, and I mean, I'm just speaking to California, but it probably applies nationwide, is that if somebody is truly being abused and there is an emergency, they want to give that person protection, right? And so that is how the whole system is set up. So, I mean, as you've mentioned and as we've touched on, when you're getting that temporary restraining order, you literally don't even talk to the judge. You just fill out this piece of paper. And as you mentioned, you don't even have to be there. You can have an attorney go and drop it off for you if you want to.
Or even an advocate, right? There were times I dropped them off to the court, right? I didn't see the judge, but this was in New York a while back. It wasn't that hard. I would just go in and hand it to the clerk, and the judge would sign it. I mean, it was that easy 20 years ago, mind you. Things have changed. Okay, let me be very clear on that. As I said earlier, I'm a little older than you. But it's amazing to me that people, I understand the reasoning behind it because they do want to protect an actual victim, right? But it does also, if we're being honest, put the person that's being accused behind the eight ball right from the get-go. They don't know this is all going on. And they have no way to defend themselves. And then more often than not, it's a sheriff that will show up and say, hey, buddy, you're out. And, I've interviewed police officers on this show before. It's the one thing they hate doing more than anything else. I've had numerous sheriff's deputies, police officers tell me they hate this. They hate domestics in general, as they'll say it, but this particular one, because they know a lot of times they're false. And it's a huge risk to them because when you're getting blindsided, you don't know how they're going to react. And it's scary. But again, I want to kind of take it from there. So if someone goes in, gets an order, whether it's ex parte or, however they've gotten it, it gets served. I think one of the issues that I've seen before is that the people that are accused don't know what to do. Right. So the sheriff has knocked on their door, or deputy or police officer, whomever, Leo will say. And, here, Mr. So-and-so, or here, Mrs. So-and-so, I have a summons, a notification. There's terms for it. You need to vacate the premises immediately. You have 5 minutes to pack a bag and get out. People make a lot of mistakes in that time, as I'm sure you know, and I think you've covered in a couple of your videos. So can you talk a little bit about what you should be doing right from the get-go? Because I think in your one video you said it literally can make or break your case.
So, I mean, you have to get out within 5 minutes and don't plan to come back. I have actually had people I've spoken to who set up cameras, who take stuff that belonged to the other person. Don't do any of that. And I mean, the first thing, once you leave and once you find a place to stay, and I've known people who slept in their cars, is, read it carefully and look at the court date and make sure that, you have it calendared. It might be in a few days. Usually you're supposed to get more notice than that, but sometimes you don't for whatever reason. So you want to read it carefully and really start to think about, okay, if these are false allegations, what is my side of the story and what proof do I have, and start gathering that and getting it ready. Because the thing about the restraining order hearings, and this is, whether you're going to have an attorney or not, is that you have very little time to prepare for that first hearing usually. And you can get a continuance, but you really want to start getting ready right away and getting as organized as you can.
Yeah, you're talking, like you said, it could be a matter of days before that hearing. It's not uncommon, though, to be 4 to 6 weeks out. In my experience, you would know better than I would. Again, different parts of the country have different things. The courts are overwhelmed everywhere. I think you would agree with me on that. But again, the police officer has shown up. Now, I don't know if you saw the video that was done last August. A gentleman by the name of Ulysses Slaughter got served without any notification. The only reason he knew he was getting a divorce is the sheriff showed up to a victim from the house. And he did video. He took a video of the police officers, and it was well done. It actually went viral, millions upon millions of views, and I've had him on the show. But one of the questions I've always had in the back of my mind, and again, it's different in each state, but is that the right thing to do? Like, he was videoing the police officer saying, "Why are you here? What is the reasoning? Blah, blah, blah." And to the absolute credit of law enforcement, they were fantastic. They treated him with dignity, respect, and all that, but they had a job to do. Should people be thinking about something like that, or would you say that's a no-no?
Okay, so they're not showing up to arrest him, because if they're showing up to arrest you, definitely don't try to take video. In that situation, I guess, and I haven't seen the video, but I don't really see the point in him making that video. I mean, law enforcement, they are really doing their job. As you mentioned, they don't even like doing this, but all they're doing is handing you the papers, doing exactly what they're supposed to do. And I can understand wanting to take a video, and I mean, it must feel very, very shocking for this to be the first time that you even hear that you're getting a divorce. But I think that the best thing that you can do is just to comply and take your time to think about your defense instead of immediately trying to fight back, go on the offensive. I guess by videoing them, you're sort of implying that they're doing something wrong, and they're just not. So I just don't really see the point there.
Having interviewed him and talked with him several times, and full disclosure, I consider him a friend now. Okay, but I think his reasoning for doing it, and to be very upfront with you, he's a black man, and police showing up, I think that was part of the reason. And I would never put myself in his shoes to answer for him, but he has said similar things. It was just, he was trying to protect himself because, again, he was blindsided. But the other side of it too is, you're pushing a button you may not want to push, right? It's, and that's why I wanted to get your opinion on it. I hate putting you on the spot that way, but these are things that happen, and it's good to get a legal perspective on it, understanding that states are different that way. But as I've said to many people, and I know you've kind of intimated in your videos, is your defense, I should say, starts right then and there, right? It's if the mistake I've seen guys make, I don't know how many times, and I'm sure you have, is they get angry. Yes. And then, in some cases, they get violent. More often than not, they get angry, and I'm not doing that. Not the brightest move, because it then puts you as their attorney really behind the eight ball. How should you, like you said earlier, you should just up and leave, comply with everything, but what should you be thinking about as you're doing that? Is there anything else other than just get out, or is there something that can be done to kind of lay the groundwork here? Is there something you should take from the house? Maybe. I don't know. These are questions that I get all the time. I thought I'd ask you that.
Right. So, I mean, that's a good point. I mean, from a practical standpoint, what you are going to want for your restraining order hearing are, all of your messages, emails, photos, everything that you might have that you might want to use as evidence in the case. So if you have enough time, and you can always ask the officers if it's okay if you do this, so they know what you're doing, you want to take your computer with you, whatever electronics you have. Because otherwise you're going to be way behind when you're trying to retrieve things, maybe, to use on your own or for your attorney, and you don't have them. They're not on iCloud. They're not, you don't have remote access to them. And the other party potentially now has access to your computer, depending on if you have it, locked and password protected and all. And I've actually seen petitioners in restraining order cases who will start posting things on the other party's social media. and trying to make them look bad, claiming that it is from them because they left their computer unlocked when they left in a rush.
I've actually seen the same thing. That was one of the reasons I was asking that question. Because, if you leave behind your phone, for example, right? People on, and that's understandable, right? You got a cop standing at your door telling you to get out. You're in the rush of trying to, oh, I got 5 minutes. You might forget your phone. Next thing you know, the person who made the accusation has your phone and is doing exactly what you're doing, right? They're making their case, in quotes, against you by posing as you. Let's just go to the next step then, Veronica, if that's okay. So now, let's say this order's been issued. Maybe you've been arrested. I'll let you kind of take it from which is the better perspective, but what should someone that's been accused expect at that point? The DA is going to get involved potentially. Police are going to be doing an investigation or not. They may just rubber stamp it, because I've seen that, and I'm sure you have. How does it normally, what are the procedures from the legal and law enforcement perspective that should occur next?
Okay, so there are two different potential situations here. One is that there is an arrest, and the other is that you were just served with a restraining order, or, well, I guess a third, that's some sort of combination. If there is a combination, typically what I see happen is someone gets arrested, they get falsely accused, or not falsely, but they get accused, they get arrested, and then while they are still in jail, before they can bond out, it takes some time to bond out, the other side goes down to the courthouse and gets a restraining order. The cops sometimes will tell the alleged victim about this process to get a restraining order. So you may get out of jail, you think, okay, great, I can go back home. And once you get home, or even before you get out of jail, depending on the timing there, you're served with this restraining order and either can't go back or only have a few minutes to pick up your belongings. If we're just talking about the situation where you were served with a restraining order, the next step is you'll have your hearing, and a lot of people will just show up and think, okay, I'm falsely accused, the truth will set me free, right? So I can just explain to the judge, and the judge has to believe my side because I'm telling the truth here. And, it doesn't necessarily work like that. They don't necessarily know what the judge is looking for, how to present their evidence. And I've seen a lot of people fail really, really badly there. And I can go into, I'm kind of switching back and forth here, but I can go back into what would happen next to the criminal case.
Please do, because you're the expert here, and you're the one that's got the experience on it. Take it wherever you want, Veronica, whatever you think is best to do. I'm wide open on that.
Sure. Okay. So for a criminal case, how it works is, and this is in the state of California, and it really may be different. The process may be different in other states. So take this with a grain of salt. But in California, what happens is you get arrested. Okay, now there's a police report generated by the police department about you, right? And you bond out, you're given a court date. Most of the time when someone is arrested for domestic violence in California, they are arrested for felony domestic violence. And your bond is going to be $50,000. If you pay a bail bondsman, you're going to pay between $4,000 and $5,000 usually. And you do not get that money back no matter what happens. So then the police report gets sent to the DA's office or the prosecutor's office, and the prosecution has to decide, okay, do we want to file this case or not? This is something not a lot of people realize, because you think, okay, I have a court date, I have to be there. You'll get a piece of paper that says that you have to be there. Otherwise, a warrant will be issued for your arrest. Of course, I have a felony against me. I have these charges against me, but it's actually not true. The arrest is just the first step. And the second step is the DA actually looking at this case and deciding whether or not to file charges. That's something that, I don't know, they didn't teach us in law school. You only learn from experience, or I guess from YouTube, in learning about this process and what actually happens behind the scenes. The thing about the DA looking at the police report, we know whatever is in the police report is not going to be good for you, right? The police aren't going to say, you know what, this guy did nothing wrong, or this girl did nothing wrong. We saw no evidence of any crime, but we decided to just arrest them for a felony. That's not going to happen. It's going to look bad for you. It may twist your words, may twist the alleged victim's words, and that is what the DA is looking at. So they'll get that in your criminal history. At least in California, as a defense attorney, I try to contact the DA before the first court date, depending on when I'm hired, and also submit good things about the client, send them to therapy, domestic violence classes, etc. Which is not an admission of guilt, by the way. That is something that if you show the DA, you know what, I've gotten some sort of treatment. There's some sort of, you don't have to worry about me. I am handling this. I want to make sure I never get arrested again. I'm willing to comply with whatever. That actually can really help. Anyway, so the DA will look at whatever's in the file. So maybe a packet from me or whatever attorney, also the police report, your criminal history, and decide what to do with the case. So they could drop it. They could decide that they're not going to file charges at all. They've looked at this. They see, okay, no criminal history. You have good letters of recommendation. Police report doesn't really look all that bad. So we're just not going to file the case. They could also file it as a misdemeanor if it was originally a felony, or they can make it more serious, but that's pretty rare for domestic violence. Usually only if there's like a prior that was recent, a prior domestic violence case, or if there were like really bad injuries or something. So that's the next step. So a lot of people, they don't realize that there's actually something you can do before the court date, and they just show up. Again, they just show up for court for their criminal case thinking, okay, all I can do is show up as I was told, and there's nothing I can do to sort of intervene and possibly get this thing dropped.
You make so many good points there. I want to unpack some of it if we can. And by the way, I'm going to recommend to everyone, Veronica goes in detail on a lot of what she just said on her various videos on her channel. So we're just trying to hit the surface here, but go check them out, because I'll give you a beautiful example of one video I saw, I think it was last week. You were talking about how you can, I don't know if it was a short or a video, but you were talking about how you can sync yourself by how you respond to the cop. And you did this like little play acting thing where you were like, and forgive me, I don't remember the exact words, but it was basically the cop said, what's your side of the story? And you said, oh, I was defending myself. Oh, so you hit her or you pushed her or whatever it was. And, oh, so you did hit her, that type of, I'm paraphrasing the whole thing, but those are critical things to know, right? Because again, this all does go into the police report. And a point I want to make to people is those arrest records, and I believe it's in every state, but I could be wrong, are public record, which means if somebody Googles you, it's going to show you were arrested for domestic violence. And those records, unless they get completely expunged, don't go away. So even if you're found innocent, because I interviewed a guy on here about a year ago who was found completely innocent. In fact, they proved she was lying. So it's beyond any question. It was a false allegation. Yet if you Google him, the very first thing comes up is he was arrested for domestic violence, felony. He can't get a job now. That's why you need to take this seriously. And, oh, by the way, I'll throw this out, and you might chuckle when I say it. Show up for the hearing, because I know a lot of people that don't. Have you seen that a lot?
Well, so, I mean, I personally haven't seen it, because if I'm talking to them, they're showing up for the hearing.
Gotcha.
But I have seen, and it's really heartbreaking in some of these situations. I've seen where people just sort of give up on even having custody of their kids or seeing them, because maybe there's a temporary restraining order, and then the alleged victim calls the police and says that they violated it, and then they get arrested for that, and they're like, but I didn't violate it, and I didn't do what was in the temporary restraining order in the first place. And they just feel like, how many times am I going to bail out of jail? How much risk am I going to expose myself to? And actually, two people I've spoken with recently, who I perceive to be great dads in general, or telling me, I just want to give up. It's too much. It's one thing after the other. So I do see that where you're sort of like, there's nothing I can do here, and you just give up.
And unfortunately, that's where they come to me, right? That's how I get a lot of my clients that come to me for coaching, is they're at that point where they're broken, right? They've been broken down. You talked about, you get arrested, you got to bail yourself out. That's $5,000, let's say. If you may only have $5,000 in the bank, well, there goes your possible retainer for your lawyer, right?
Yeah.
You got to pay a lawyer. They're not free, okay? And in most cases, unless it's a criminal case, if it's on the civil side or family court side, they're not going to give you a lawyer, right? You're not getting a public defender. People don't understand this, which is why I'm trying to educate people is I don't think the general public really has any clue about this stuff. And, it breaks guys because now they've got no money, nowhere to live, by the way, right? How are you going to get an apartment when you just paid every dime you had in your bank account, assuming it hasn't been cleared out anyway? These are horrific scenarios. And again, I have no sympathy for actual abusers ever. You'll never hear me say that. I'm a victim of domestic violence myself. You will never hear me sympathize with someone who's actually guilty. But I'm also a strong believer in due process, right? And unfortunately, in these cases, due process sometimes gets trampled on. And even when it's done properly, it can break people. Talking about it from the mental side, how does you as an attorney handle that? That's this. See, I told you, sometimes I go off on tangents. This is going to be a tangent, if that's okay. How do you as an attorney, if you're dealing, let's say, a guy and he is broken, right? He's just said, I give up. What do you do? What can you say? How can you help him from your perspective?
So in that situation, I mean, I'm not a very good therapist, I would say, but I am a good lawyer. At least I think of myself as one. And so I try to tell them, okay, take a break, go do your favorite activity, whatever you have to do. Then we're going to talk again because we're going to keep fighting. We're not just going to give up, especially you bailed out of jail. You hired me. We've come this far. We're organizing your evidence. So we are going to take it one step at a time. And there's no reason to give up now. That is usually what I tell them. And I try to get them more into fighting mode instead of giving up mode. I know for me, that is what helps me. And it does seem to help them. But it's like, okay, here are things that we can do. It is not hopeless. There are specific actions that we can take. Why don't we prepare your testimony? Or, okay, let's talk about your evidence and let's get that ready. We're going to go one allegation at a time and use whatever evidence we have. Maybe it's just your testimony, but we're going to use whatever evidence we have and be ready to go through and show that those are false.
Yeah, it's again. I'll say this to the public that's listening or the audience that's listening is your lawyer is not your therapist. Okay, they have a job to do, and to your credit, Veronica, right? That's what you should be doing as a lawyer. But if you're in that point and you're reaching that point, one, a therapist's a lot cheaper. No offense to you, Veronica, but generally they're a lot cheaper than a lawyer. And actually, that's their training, right? You're trained in the law, not therapy. But as someone who deals with guys that are going through that, having a good lawyer is a key thing, right? I know you have a course that is designed to help people to defend themselves, to represent themselves. I'm just going to give you my advice. Take it for what it is. I believe you should get a lawyer in these cases always, because you could end up in prison. I mean, is it a guarantee? No, it's not, right? But there is that risk. And if I'm in that situation, thank God I've never been in it. The first thing I'm doing is calling a lawyer, because we've kind of touched on a little bit. One wrong move, one wrong statement, and next thing you know, you're behind the eight ball to begin with. Now you're really behind the eight ball. You're behind 3 8 balls or 5 8 balls for that matter. I guess the question I want to ask from this is, how do you find a good lawyer? What should you be looking for in these cases? Because keep in mind, most people, like we talked about earlier, they get blindsided with these things, right? Now they're sitting in jail. They're trying to figure out how they're going to get representation and get bailed out. What do they do? How do you find that good lawyer that can help you? And what should they be looking for?
Right. And actually, I wanted to clarify a point real quick. So
Sure.
the course that I teach, that is only for restraining orders. That is not DIY criminal defense.
Great.
You at least will have a public defender for criminal defense. I do believe that you should get a lawyer if at all possible. In terms of what to look for a lawyer. So, I was watching another video of yours earlier today, and you asked the attorney that, and I was like, man, so his answer was basically that you should pay for a consultation if needed, so you can actually speak with the lawyer, and that way you can get, sort of a feel for them, come up with a game plan. I think that is good advice. I also think when hiring any kind of professional, if it's an area that you don't necessarily know about, you should speak to a few, and you'll gain some knowledge just from hearing the same things come up. One thing for criminal cases that I would say, at least in California, is that a lot of criminal defense lawyers handle like whatever comes through the door, any kind of criminal defense. And they will not contact the DA before court to try to get the case dropped. Because for murder, for example, there's no point. They're probably going to file it. Unless you're getting in there and convincing the police and the DA that it's self-defense or something like that beforehand, which is really difficult to do, probably they're going to file it and there's no point. But if you talk to a few lawyers and you start hearing that some of them say, okay, we should contact the DA before court. This is the first thing we do because maybe we can get rid of this whole thing. We don't have to go to court. We don't have to go to trial to get it dismissed. And you hear, okay, there are some of them that say we should do this, and others are like, nah, we'll just show up at the first court date. We'll see what they do. Maybe you want to go for the more proactive one. I think that being proactive for all of this, for any type of false allegation involving domestic violence, is the best thing that you can do. I think some people's tendency is to, you don't want to think about it. You want to just bury your head in the sand, not think about it, think about something else, focus on something else, because it is so stressful and so negative. But I do think it's important to try to do all this, interview these attorneys sooner rather than later, so that you can hopefully hire an attorney, find one that you like, find one that you trust, and kind of take the burden off of yourself.
Well, again, Veronica, the question I always try and get guys to ask is this someone that specializes in this type of thing, such as yourself, right? So many people, and I'm not knocking anyone. Please, I don't want anyone out there thinking I'm knocking, let's say a general practitioner lawyer, your family lawyer, right? The one who's written your wills. They don't really have the training for something like this. And I think most of them would say that I can't help you. But you really want to find a defense attorney, correct? I guess that's the way to put it, with some experience. When they're interviewing them or when they're doing the research, is there anything in particular, like I know what you're talking about with reference to, asking for a family court attorney. You want someone that specializes in that, because a general practitioner or a corporate law attorney that happens to be your cousin on the third side, they don't have that kind of expertise. But when you're interviewing a defense attorney, this is a question I have now, because see, things pop in my brain. Let's say I was coming in to interview you, right? Hypothetically, what would be good, like maybe 2 or 3 really good things to ask you to say, all right, this is the person I want to hire, or maybe this isn't the person? What would be like, give me the other side of it. Give me the secrets on what we should be looking for.
Okay, so I think you would want to ask them about if they've had similar cases before, how many cases they've had like this. They may not have an exact number. I honestly don't know how many domestic violence cases they have, but you would want to get a feel for, right, are they a specialist, or did they just take, whatever comes through the door? I think you would also want to ask them about the entire process, the entire timeline of a domestic violence case. And of course, yes, we all hope that it will end before the first court date, but what if it doesn't? Then what happens? What's going to happen at the next court date? What is the process? And you're asking that, or I'm suggesting asking that, not just to get the information. It's going to be a lot, and you can always ask again later. You can always look it up. I have videos on it, but so you can do that. But you want to see how patient are they with explaining it to you, and how well do they explain it to you. I'm not trying to knock anybody either, but I also think one thing that is really important is see how good of a listener they are and how much they care about what you have to say, because a lot of attorneys can be a bit impatient or not really paying attention to the details of your story that might make a difference. And I have seen this with people who are not happy with their attorney, and they're calling me down the line. They explain, he never remembers my story. He doesn't remember my name. He doesn't remember if I'm with the alleged victim, doesn't remember, any of this, and doesn't really seem to pay much attention to it. So I think that is probably pretty big because with false allegations, I really think that the devil is in the details. And that is where you can find ways to poke holes and then widen them in the other side's story.
Yeah, it's really not all that different from trying to find a family law attorney, but there are some specifics you need. I mean, very good points you made. You want somebody with a little bit of experience. That's not to say someone coming fresh out of law school might not be a great attorney, but if they have no experience, like you said earlier, right? You learned things after you got out of law school. That's where you want to have that experience. And that's not a knock on anyone. It's just your life is in jeopardy in some manner of speaking, right? So it's definitely worth putting some effort into finding a good attorney. And your point, it's one that I've made a million times, is you want an attorney that one is going to be available to you. I can't tell you the number of guys I've talked to where I can never talk to the attorney. I get the secretary or the paralegal, which some of them are great too. Not a knock on any of them, but I want to talk to the attorney and he or she is never available, which in some ways I would argue might be a good thing. If they're in court all the time, they're defending their clients. But I'll set that one aside. Hey fans, I just wanted to take a quick break from the show to remind you just how much we here at Men Need to Be Heard truly appreciate and value your support. And we'd like to ask you to do us a little favor. Could you take a moment and give us that like and share this video with your friends? And hey, don't forget to give us a comment and let us know how we're doing. Your feedback means the world to us, and it helps us to continue bringing great guests and even more content each and every week. And don't forget to subscribe to the channel so you never miss an episode. It's the best way to stay up to date with all of our latest discussions, interviews, and deep dives, as well as it helps the channel to grow so that we can continue to raise even more awareness on the issues men and boys face in today's modern society. So hit that subscribe button and become part of the Men Need to Be Heard community. All right, that's it for now. Back to the show. Where I want to go next, Veronica, is kind of walk through a hypothetical case of some sort. Okay, so they've come to you, they've been served. Let's say, for the sake of argument, they've been arrested. Just throw that in there. They've now come to you. They've bailed out. All right, Veronica, I'm here. Here's the allegation that was made. Here's the paperwork I was given. Kind of walk us through what happens next, because again, we kind of touched on this earlier. I don't think people have a clue how it all works. So if you can, and I know you cover this in a lot of 20 videos, but we're going to try and get it the next few minutes. Walk through all of the steps that you would see as a defense attorney, and kind of help. Like if I were to ask you the question, what should I expect? There we go. See, walk me through a situation.
Okay, so you've been served with a restraining order, you've been arrested, and you have, so just both issues that you have coming up. The first thing that I would do is I'm going to read the false allegations against you, but I want to go through your story. So I want to go through step by step and make sure I understand your story. What I will typically ask clients as we are going through what happened is, do you have any witnesses? Do you have any documents, anything that you think right now would be related to that, that would help show that your side of the story is correct? And I want to start gathering all of that as soon as possible. I actually have a whole process for gathering evidence with restraining orders because, and sometimes it applies to domestic violence criminal cases too, but for restraining orders, people tend to either not have any evidence that they're handing over, or more likely they have a mountain of evidence. It's so much that the judge is never going to look at, and I need to start curating it really soon. So I want to make sure I know, okay, what can I expect? And then we're going to gather all of that evidence. The next step that I take, and this would apply more to the criminal case, is I want to gather all the information about you, good things about you, hardships you've experienced, if there are any, your education, work, family life, if you help your grandma, if you volunteer at a soup kitchen. I want to gather all of that because For criminal cases, a big part of it, and especially less serious ones like domestic violence, a big part of it is showing who the client is as a person. You can't do that usually as much for restraining orders. You can do it for the custody part if you get to that part of restraining orders, but not overall. The judge is not going to let you make a big speech about your client's entire background. But for criminal, I do need that. And then, and this is the part that I get asked a lot of questions about and is maybe a bit more controversial, and I sort of alluded to, is I will come up with some things, but this is for the criminal case. I will come up with a plan for my client of what they can do to build their what's called mitigation. Mitigation is the good things about you, all of that. So most of my clients, I will send them to therapy, not because they necessarily need therapy or that I don't want to talk to them or be their therapist, but because it shows that they are proactive and that they are taking steps, not because they're guilty, but because this was an event that they never want to have happen again. They're not a criminal. They don't want to be arrested. Actual criminals usually are not going to want to do therapy or are not going to be willing to do any of that. They just want to get out of jail and carry on with their life of crime. I mean, at least that's a stereotype that the DA is going to have. And if they are still with the alleged victim, then sometimes I'll ask them to go to couples counseling and if the alleged victim does not actually want to press charges, because it's not up to them, it's up to the DA, then I will get a statement from them, usually get it notarized in case they change it later and they go back throughout the life of the criminal case. I want to make sure that they can't say that they didn't write it or that I made them write it or I wrote it. And I will send them to sometimes domestic violence classes. If there is any issue with, like, let's say that they were drunk when the police came. Doesn't mean that they have a substance abuse problem, but if I can have them do some AAs, they're free, you can do them online, that actually will help too. And again, the idea here is that we get it dropped before court, or if that does not work, maybe you hire me after the first court date, or maybe the DA just decided, you know what, I am going to file this. Maybe it's a more rural county where they are not as busy and they file more cases. Then my goal is to get you to do some more of those classes and have them dismiss the case in exchange. Of course, we can go to trial if they don't give us what we want, or if you don't want to do the classes, we can go to trial, but there's a lot of risks there. So those are the immediate next steps. I'm giving a little bit of a monologue here.
No, that's fine. I'm just sitting here shaking my head. This is great advice, Veronica, because again, people don't understand this all, right? They have this belief, I think you kind of said it earlier, that one, they want to believe it's just going to disappear and go away. It's not. And two, I just got to tell my side of the story and they'll believe me and it will go away. No, it won't, right? And that's why this is valuable knowledge that people have. When you're doing all of this, I'm going to play devil's advocate if I may. And I don't disagree with anything you said, just for the record, okay? But I can hear the guys out there. You want me to take a domestic violence case when I'm completely innocent? I'm sure you've been told that one before. Can you kind of explain that or go to therapy or any variation thereof?
Yes. Okay. So I hear that all of the time, and I do understand that. And I can imagine feeling the same way. And it does sort of seem like, okay, it's an admission of guilt, kind of. Some people might think that. Plus, there's an expense, and it's annoying. If you don't need to go to domestic violence classes and you're doing it, it is annoying. What I tell them is that this is sort of what we're trying to give, especially if you have no criminal history. We're trying to give the DA almost like a CYA, because so the DA's nightmare when they're deciding whether or not to file the case or give you, a much better deal than most people are going to get, classes in exchange for a dismissal or something like that. Their nightmare is that you are going to go and seriously hurt or even worse the alleged victim in the case. I mean, imagine the headlines. DAs are elected officials. It would be a big problem for them. I mean, I'm sure that they actually, some of them at least, actually care about the alleged victim too. But I mean, that's their nightmare, that it's career ending because they gave you a break. But if they can say, okay, but sure, this person that I gave this break to went and did the super violent thing, they can say, okay, but this person they were going to classes. They were under the care of a therapist. What more do you want me to do here? I did everything that I could. They were under another professional's care. That gives them it covers them. So that is typically what I tell them. It also helps, as I mentioned, that you're being proactive, that you are willing to comply and do something, and that you are horrified by this situation. You're not okay with being arrested, and you are trying to make sure that this never happens to you again. So that's part of what I tell them, but I also explain to them, especially if they're still not convinced, the alternative. Okay, so you didn't do anything wrong, right? So you're not going to take any classes. You're not going to go to therapy. Okay, that's fine. You don't have to go, right? You don't have to do any of that if you don't want to. If the DA files charges against you and they offer you, even if you haven't done any classes, let's say they do offer you classes in exchange for dismissal. They won't outright dismiss it, but they want you to do some of these classes and you still don't want to do it. Okay, what you're telling me then, and it's okay, and I love going to trial, but you're telling me that you want to go to trial. Okay, trial is very expensive. It takes time, and there is risk that if you get convicted, you lose your leverage, and it's up to the judge to decide. Now, how good of a chance do you have to win at trial? I mean, it depends on the case. We go through the evidence, and I would give you my opinion once we have the evidence, which is only if the case is filed. But there's still that risk, right? It's going to be 12 random people who are going to look at you, see that you are in the defendant's chair. And a lot of people think, okay, if you're in that position, I've never been in that position, you must have done something wrong. And it is up to them to decide whether or not to convict you. The alleged victim really wants you to be prosecuted, really wants you to potentially go to jail or be convicted. That alleged victim is going to get up on the stand. Maybe they're going to cry. They're going to tell their story. And if the jury buys that, okay, now you're going to potentially have this conviction, which probably will require you to do classes unless it's just straight prison time. You probably will have to do the classes anyway. And now you are poor, you have been under stress for a long time, and all because you didn't want to do the classes. So, I mean, some people do want to do that. Some people don't have a choice for whatever reason, maybe their professional license, they don't really feel like they have a choice. But they basically what you're saying is you were willing to go to trial, take that risk, and accept the conviction rather than just take the classes.
Yeah, I mean, again, I when I'm working with guys and we have this conversation, thank you so much for laying that out. The argument I always say to them is, look, you want to go to trial, I get it, right? You're innocent. I would want to go to trial, to be honest with you. But, let me put that big but in there. You're talking potentially hundreds of thousands of dollars. I mean, I know of a case where a guy was $500,000 defending himself, right? $500,000 over years because he got convicted, then appealed, it went to appeal and all that. I mean, that's an extreme case. But it's not going to be $2,000 either. Let's be realistic about it. That's number one. Number two, and you touched on it, the DA wants to CYA. So does the judge, by the way. Right? I've interviewed family court judges and other judges, and they're like, off the record, I rubber stamp these TROs and all that because I don't want to make that mistake and the guy goes out and kills the wife the next night, because then my name's going to be splashed all over the papers. How could I let this happen? So they're going to CYA. And then put yourself, for you out in the internet world, sitting in that jury box and hearing, like Veronica said, this poor unfortunate victim crying their eyes out, because some of them are very good actors, even when they're lying. And you go, I can't take that risk, guilty. That's what you're up against. Does that mean you can't win? No. And I think you would agree with me on that, Veronica. But that is also the reality. So if taking a few classes and going to see a therapist can give you at least that bit of protection, I guess is the word, I would do it. And I will tell you right now, those domestic violence classes, I had to sit through them when I was getting trained as a peer counselor. They're awful. I mean, they are awful. You will come out of there feeling like you need to take 3 showers. I understand that. But to Veronica's point, a little preventative maintenance can prevent really bad things. I want to kind of touch on something that you talked about, Veronica, which is, I mean, realistically, average case. I mean, we're not going to get into specifics, and it varies by locale, but when people do take it to trial, do they have a decent chance? Because the perception is you have no chance at all to defend yourself or be found innocent. My experience having worked with people is they tend, if it gets to trial, they tend to do better than they think. But I'm curious what you're finding as someone who represents someone. Do you think it's, one, do you think it's fair? And two, do people have at least a shot, I guess is the way I'll put it.
I mean, it depends on the case.
Obviously.
I think you knew I was going to say it depends.
Obviously, but
I mean, yes, you do have a shot. I typically, what I advise people to do is, unless like if you have, so I don't know, I had a domestic violence case that went to trial. Not that many of them go to trial, but I had one that went to trial because the guy was on federal probation. So he couldn't take any kind of, even if he took classes in exchange for dismissal, that would have violated him and he could go to federal prison. Or someone who the DA just would not offer him anything less than felony probation, doesn't want a felony. That's fair. I wouldn't either. I would have gone to trial in that case too. You know, if it's going to ruin your life, you have to do it. I think, I mean, so I'll tell you some things where I think the chances of you going to trial and winning would be really low. If you talk to the police when they came out and they arrested you and you made some sort of statement that I can't get thrown out, they Mirandized you, whatever, I can't get it thrown out, and it does contain an admission. Sometimes people think that, you know, maybe it was some sort of self-defense, but it was excessive force, something like that. If you confessed, that's going to be really, really difficult. Another thing, somebody I consulted with recently, the other person had broken bones in their face, and he had told police, well, she probably did it to herself. Nope. I mean, that could be the case, sure, but come on. I mean, she didn't do it to herself, right? Nobody's going to break their own bones in their face, or it would be very difficult to get a jury to believe that. If it's like a bruise, if it is a red mark, something like that, a cut, a scratch, sure. Okay, that's a reasonable argument. But some arguments and some defenses, they're just not going to be reasonable. How the victim testifies too. So if I do have somebody and I represent them for the restraining order and for the criminal case, I actually usually want to do the restraining order hearing first for a variety of reasons. And most attorneys do kind of the opposite. But I want to see how the victim testifies. And I want to be able to use those statements in the criminal case if they're inconsistent. If the victim is super consistent and the victim testifies very credibly, then we know that it is going to be all that much more difficult. If the defendant has a domestic violence conviction that is going to come in, or if they had numerous domestic violence arrests, then in some cases can come into evidence in California, I think you lose the benefit of the doubt with the jury. If they've heard, okay, she called 911 2 other times within the past year, they're probably going to convict, frankly. So I think if you are thinking, maybe I want to go to trial, you should have a consultation with an attorney, maybe even early on, and kind of have your plan, and talk about, okay, here's the evidence against me. What chance do you think I have?
Yeah. Again, it's so case dependent, right? We're talking very loose generalities here. And again, I would encourage anyone anywhere, if you're running into this, go find an attorney like Veronica and get honest feedback relative to your state, because state laws do vary in these cases. So, you kind of touched on this is, as you are as an attorney, you're seeing the evidence that's there or lack thereof. You're talking with the person. It's not uncommon, I know, for the DA's offices to try and offer deals, right? Look, if you do this, we'll plea it down to a misdemeanor, blah, blah, blah. And they make it sound like they're doing you this huge favor, and they may be, to be honest. But they don't want to go to trial any more than you want to go to trial, I'm sure, in many cases. I always hear from guys, and that's why I want to ask you this, is either never take a deal, right? Or take the deal because you're screwed no matter what. And again, let's understand this is entirely case dependent. But when you're sitting there as a defense attorney, and an ADA, assistant district attorney, for those that don't know, is working the case, because that's usually who has it. And they're saying to you, look, we'll do X for your client, we'll plea it down, blah, blah, blah. And you have a strong case for defense. Do you sometimes, and again, just hypothetically speaking, do you sometimes say take the deal anyway because it's just you're going to be better off in the long run? Or would you kind of go, well, maybe I need to reject it? Because I'm curious, because I hear so many times from guys, both sides of it. What in general would you say to do?
I would say don't take the first offer. So I don't like either one of those pieces of advice because they're sort of always and never statements. And it really does depend on the case. But almost always you do not want to take the first offer. I mean, if there were not bad injuries and your client has no criminal history and they're saying, oh, he was booked for a felony, we charge him with a felony, we'll bring it down to a misdemeanor. I mean, that's not a good deal. I don't think that that's a good deal at all. They were just kind of overcharging him in the first place because they wanted to have some room for negotiation. I mean, my client will still have a conviction then. Yeah, it can be expunged, sure, but a conviction could still have devastating consequences for them. So I would say keep trying. Sometimes if I think that my client has a good chance at trial because I have documented inconsistencies from the alleged victim, I will show that to the DA. I know I'm kind of like revealing my hand. I don't think it really matters in the context here with the DA. The DA probably hasn't looked that closely at the case. DA probably has not looked at what the alleged victim wrote in their application for the restraining order or reviewed the body worn video and those statements there to see if there were any inconsistencies. They probably just like flipped through the police report. So I like to sort of highlight those. And then maybe my client is still, unfortunately, still going to classes. And I can show them, look, at my client's doing even more classes. They've almost done, in California, they want you to do 52 weeks of classes typically. Sometimes you can get them to give half, but I know it's a lot.
Wow. I'm like, that one stunned me, Veronica, because in my experience, it's been like 3 to 6 months generally. So California is 52. Again, every state's different, right? So you stunned me on that one.
Yes. Yeah, I didn't know it was less in other states, but yeah, so 52 weeks is what they typically want. But sometimes if they can see that their case is weak and you're focusing on, okay, here's why my client can't take a conviction, even if it's a misdemeanor, they will let them. They will offer the client to take fewer classes. Yeah. Sometimes that can happen. And again, if you get it dropped before court, you don't have to keep taking the classes. You're done. Like once if they drop it, then you're done. You don't have to keep going or anything like that. So that's what I usually encourage people to at least try to do.
Yeah, I mean, again, every case is individual. It depends on the situation. But I'm going to circle back. And I'm not saying this because I have an attorney sitting here. Get an attorney because they're the ones that know what they're talking about with this. Especially if it's a criminal case. I don't think you should ever represent yourself in a criminal case. That's my 2 cents. And I'm using that as a segue, Veronica, because now I want to shift away from the criminal side and go to what you cover in your course, right? The restraining order side, right? And I guess the first question I want to ask is everybody, again, assumes innocent till proven guilty and all that. Is it any different, really, when you're dealing with just a restraining order versus let's say, an arrest? And can you kind of talk about what those differences might be?
Sure. In terms of like how much of the benefit of the doubt you think you get?
All of that. Like in general, like, how is it handled? Again, we're kind of circling back. And where I'm kind of thinking in my mind is preponderance of the evidence beyond reasonable doubt, because people think for a restraining order it's beyond a reasonable doubt, and no.
Right. Okay. So for a restraining order, at least in the state of California, the petitioner has to show that it is more likely than not that a restraining order is needed to prevent future domestic violence. So basically, slightly over 50%. In a criminal case, it is beyond a reasonable doubt. So if you can think of a doubt that is not unreasonable as to why the defendant is guilty, then he should be acquitted. So the burden is lower. It is easier for a petitioner, per the burden of proof at least, it is easier for the petitioner to get a restraining order. But in a criminal case, I mean, you typically have a jury, they're looking at you sitting there in the defendant's chair and they're thinking, you must have done something wrong. I mean, the good thing for a restraining order is even though the burden is lower, you have a judge who has seen a lot of these cases, who has probably hopefully denied restraining orders in the past and has seen people lying, and has seen what I think Dan has seen and what I have seen, which is that petitioners have outside motives sometimes to make up these lies. And so they may be more suspicious, depending on the judge, they may be more suspicious of the petitioner and the petitioner's motives to say that you had committed domestic violence.
Yeah, it's interesting. I've never actually observed a criminal case, but I have observed, where they're getting restraining orders done in those cases. And you sit in a gallery, and I kind of equate it to the first time I walked into family court. And back then, this is how old I am. L.A. Law was the big TV show, and you thought, Law and Order and L.A. Law was going to be the case, and the truth shall set you free, and all that stuff. And it was anything but. I was like, in fact, I'm writing a book on that too. Like, I had no idea. Okay. It's really not that much different in my opinion, when you're dealing with, you're in front of a judge for defending yourself on a restraining order, is that, yeah, truth matters, or it's supposed to matter, but the honest fact of the matter is people lie and they get away with it sometimes. And, you're sitting there as the defendant going, I know she's lying, but they have no proof of it and all that, and it can blindside people, which is where I want to kind of go next, Veronica. So someone that's in that situation, what are some tips that you would give them? Let's assume, for the sake of argument, they're going to represent themselves, at least initially. What should they be thinking about? I'll start. Emotion has no place in the courtroom. Okay. And I'll let you kind of take it from there. What other tips would you give to kind of help people prepare themselves prior to court and then in court?
So one thing that shocked a lot of people is they don't realize that they are going to get probably a very limited amount of time to present their side of the story. So maybe they are prepared to talk for an hour and present their whole relationship and how the other side is wrong and give their side of the story, but the judge only gives them 5 or 10 minutes or cuts them off. And that can really throw you. You're already in a stressful situation. And so I tell everyone, sometimes you do get longer, but I tell everyone to be prepared to get your whole case out in 5 to 10 minutes. Another thing is, a lot of people, and I did touch on this before, you want to present like the kitchen sink of all the text messages with the other person. The judge does not have time for that. The judge may get frustrated. They may have 25 cases that day that they are trying to get through, sometimes more, and they are just simply not going to look at all of that. So if you don't have it organized in a way where you can, first of all, you've curated it, and you only have the really important documents, if you have not done that and you don't have it flagged, it's going to be all the more difficult for you. So what I tell people in terms of evidence is preparation really is key. You should have at least 3, ideally 4 copies of every piece of evidence that you want. If it is a text message, make sure that you have the date and time. For restraining orders, at least in California, judges really want to focus on the timeline and all of the dates. And this goes for the petitioner or respondent. Every piece of evidence that you have, you should have a date for it. And it should be directly relevant. So that's something that a lot of other people don't really understand. So relevant means basically that it's important, that it's more likely to show that it's likely to show that something is true. But you only want to focus on things that the judge is actually looking for. The judge is looking for, okay, do I need to issue a restraining order to prevent future domestic violence, right? So has there been some sort of recent act of domestic violence, maybe even just harassment or a text message? Have you guys not talked in 6 months? That's going to be really important to the judge. Who cheated on who, if you're the respondent, if the petitioner, was abusive to you, and I'm not talking about like a self-defense type of scenario, but the petitioner was abusive to you or called you names, usually that is not directly going to be relevant and something that the judge wants you to focus on. And you really want to make sure that you know every piece of evidence that you're going to use. That includes your testimony, what you're going to tell the judge. You need to know and understand and make sure that it is actually going to inform the judge as to whether or not it is necessary to issue a restraining order to prevent future domestic violence. So another thing I see a lot of this happen to a lot of people is they will get cut off by the judge because they start talking about things that are not important, or they don't get to the point soon enough. So you want to get to the point very quickly so that the judge can see, okay, you're not just rambling on about something totally unrelated here. This is actually going to help me make my decision today. Another tip, do not interrupt the judge. So Dan, I think I saw in another video of yours where you were talking about I think it was your first time in family court, and you mentioned something about how when the other side they're making allegations against you, you want to say, well, that's not true, when they're giving their statement.
Right. Don't do that.
Yes.
Do not do that.
I've literally seen people say, objection, that's a lie. I mean, great that you got the objection part, but that's not a valid objection, and you're going to lose the judge's attention, and the judge may just completely cut you off if you start doing anything like that. So you want to make sure that you don't interrupt. Like how it goes is the petitioner gets to go first. They give their side of the story, their evidence, and their testimony is evidence, and then you go. So you have to wait for the other side to go and finish first. The judge may also interrupt you and ask you questions. Let the judge do that, and make sure that you really stick to answering the question and you don't go off on a tangent. Because again, they will get rid of it. And going back to objections, there are certain objections that you can give. So one is hearsay, where the other side is talking about something that someone other than you said outside of court. Their mom said something about how you're always abusive, or they've never liked you, whatever, something like that. You can say objection, hearsay. There are a few others. I won't go into super detail right now just because we have limited time, but the course that I have on how to represent yourself in a restraining order, in that course, I do teach you those objections. You also can, although you don't have to, ask the other side questions usually. Sometimes the judge won't let you. But in the state of California, they are supposed to, for domestic violence restraining orders. They are supposed to let you ask the other side questions. So some people don't feel comfortable with that. You don't have to, but you can. And that is another thing that I teach you how to do in the course, to sort of poke holes in their story. If you don't want to do that, what you can do instead is simply give your own testimony. And if the other side said something that wasn't true, then you can explain that it's not true and what the truth is.
Yeah, I mean, that is some tremendous advice you just gave. And by the way, for those of you that have followed me or heard me talk on it, it's not that much different than family court, right? Bullet points with the judge. Be respectful. They run the courtroom, not you. Okay, and one point that I'll make that was a really key one is listen to what the other side is saying, because sometimes you can tear their case apart because you know something and you might have proof that shows otherwise. It's unfortunately so many people get emotional in that, right? And if that's the type of person you are, get an attorney. I was the exact opposite. My attorney called me the Terminator because I had no emotion whatsoever, whether, it was a huge thing against me or a huge win. I've shared this story before. I was up against a guardian ad litem, and the family court judge looked at her and said, he knows the law better than you do. Now, if I had gotten up and cheered at that moment, which I wanted to, don't get me wrong, that would have been a big mistake. I just sat there, okay, nodded my head a little bit and left it at that. Being prepared ahead of time is key. And that's where a course like you're offering, Veronica, and I think anyone who's facing something like this should go take it or get it, because little things like the tips you just gave can make all the difference in the world. And, if you're innocent, you don't want a restraining order against you, because then the other side of it is you're setting yourself up. Because I'm sorry to say, but once they get that restraining order, there are people that will try and take advantage of it and place themselves near you or you near them. And next thing you know, you violate it and now you're in jail, right? So what are some of the other things that you cover in your course, Veronica, that would really help the audience to understand it?
So in the course, I really try to teach you step by step everything that you need to go through, because I think it can get very overwhelming having this document that has all these false allegations from someone that you were very close with, right? And now all of a sudden you have to go into court and try to fight against this. So I give you an outline of step by step. This is actually what I do as an attorney. Okay, here's their allegation. Here's my side of the story. And then here are my pieces of evidence that support this, if I have any. You won't always have any. So I go through that, explain what the judge is looking for, explain some cross-examination styles that I use, explain objections. So, I mean, I have won restraining order hearings just by, well, mostly by keeping almost all of the other side's evidence out. So if you're against somebody who doesn't, I'm an attorney. So if I'm against somebody who's not an attorney, obviously I have an advantage, but I just teach you like, there are only a few tricks that you need to use in that situation. So I teach them to you. Like if they have a video, for example, and in the video, you are talking and they are talking, and you object based on hearsay because they are talking in the video, that's an out-of-court statement by somebody other than you, and now they can't show the video at all. Okay, maybe they were really counting on that, and they do not know how to respond to it. Now, on the other hand, if the other side has an attorney, of course, yes, you should get an attorney if you can. But if the other side has an attorney, a lot of attorneys are not that prepared for restraining order hearings. They don't take them that seriously. And if you actually know what they are talking about when they say objection, hearsay, and you can say actually no and sort of respond to it, you may throw them off too. And I've actually had people who have taken the course who told me I was against an attorney and I won. I'm like, okay, well, that made me a little nervous that you were against an attorney, but I mean, they won because they basically, the other side underestimated their, like, how prepared they would be able to be, and were probably underprepared themselves.
Yeah, and that's a key point, preparation, right? If you're going to defend yourself, and I've talked about this from the family court side, be prepared to put many, many hours in, because judges will give you leeway if you're representing yourself, but they'll only give you so much, and they expect you to know the law. You may not be an attorney, but they're not going to just let you do whatever you want. You have to understand that, when I represented myself in family court, I had an attorney for the important stuff, but I did a lot of it myself. But I was averaging 20 hours a week of, research and learning. And as I said, I put all that effort in, and yeah, I beat an attorney, right? Guardian ad litem, destroyed her, actually. Proud moment, can't you tell? But it didn't just happen because I walked in the courtroom and just suddenly did it. I had spent probably 2,000 hours beforehand learning that stuff. It is a commitment, and if that's not something you can do, that's fine. Get an attorney. That's what they're there for. But the other side of it is, you've got a great resource with the course that Veronica's offering that you could take advantage of, which, as Veronica just said, can help you really succeed on your own. So take advantage of it, guys, right? Listen, you got an expert. Might as well take advantage of it. Veronica, we're running out of time. I want to give you a couple of opportunities here. First of all, if someone wants to follow you on social media, because I found you on YouTube, but I know you also have, I believe, TikTok, Instagram, a few others. How can people find you and follow you?
Sure. So my handle on everything is Veronica T. Barton, ESQ for Esquire. YouTube is my baby. That is where most of my videos are, my long form videos. I'm kind of dipping my toe in the TikTok waters too, so you can also find me on there. And I have some kind of fun things planned for TikTok with more of those skits. And then the course, you can get a free class in the course if you just want to see, what all of that is about. You can go to defeatthedbro.com, and there you can get your free first class and see if the course is something for you and something that you think that you can do yourself.
Yeah, TikTok can be fun. I mean, I've got a couple 100,000 followers on there. It can also be a nightmare. I'm just letting you know. There's there's moments it's good, there's moments it's bad, like anything in life, right? But I encourage everyone to go follow her YouTube channel. And even if you're not involved with dealing with a false allegation, or if they're guilty or whatever, go watch it because they're very educational. Veronica, one thing I want to say to you is, one of the criticisms I always have for attorneys when they try and do videos on YouTube is they jargon it up too much, right? Too much legalese. You make it so easy for the average person to understand. And as someone who's coached people, who's been involved in this stuff for 30 years, I honestly believe it's one of the best channels I've ever seen for that. And I'm not just saying that. I genuinely mean it, because you explain it. You don't sugarcoat things, but you explain it in ways that people can understand. And a lot of attorneys can't or won't do that. And I just want you to know that I appreciate you for doing that.
Oh, well, thank you so much. That's a fantastic compliment. And I think a lot of the law here and what you can do, it's not actually that complicated. Maybe that's why we have legalese, so we can make it sound more complicated.
Yeah.
It's really not. And there are a lot of things that you can do to help yourself that people just don't know. Either they don't understand, their attorney doesn't tell them, or they don't understand what their attorney is saying when it's explained to them. So I really do try to do that, and I appreciate that.
Yeah, I haven't watched all your videos because there's a lot of them. You're as bad as I am at making videos. We make a lot of them, don't we? That's a good thing. But, and if you have an attorney, I would encourage you to go check them out too, because that can help you to help your attorney prepare your case. One thing, final thought. Speaking of final thoughts, Veronica, any final thought that you want to share with the audience before we wrap things up?
I don't think so. Thank you so much, Jan. And I am really enjoying looking at your channel too, and sort of exploring. There's a lot to learn on here.
There is. And, my goal with all of it is to kind of educate people, raise awareness of this issues. Yes, it's focused on men and boys, but the reality is it affects women as well. And the more we can have conversations, the more we can help each other. I just think it makes the world a better place, doesn't it? Yeah. All right, folks, we're going to go ahead and wrap things up. What an amazing show, huh? Veronica just shared a plethora of information. And again, I encourage you to go to her YouTube channel, go to her website, look at the course, and follow her on the various social medias, because again, whether you're facing a false allegation or you're not, you can learn a lot from it. And there's so much misinformation out there, and what Veronica does is trying to clarify things and make people understand them. And again, that's the goal of this channel, is to raise awareness on the various issues that men and boys face. If you enjoyed this, if you got something out of it, let me know in the comments below, will you? I love engaging with the people that watch the show, although sometimes they don't have very nice things to say, but sometimes I like to play along with them too. Also, hey, give me that like, right? Because the algorithm is the algorithm. You've heard it from a million creators before. You can really help me to spread the word and raise awareness on these issues by giving that like. And if you haven't subscribed already, why the hell not, right? No, come on back. New shows go up every Sunday for the podcast at 11 a.m. Eastern. And don't forget, I am live on Wednesdays from 4 to 5:30 with my co-host, Lindsay, a.k.a. Squirrely Girl, where you can talk to us directly. And we're on TikTok, Instagram, YouTube, Twitter for all those. It's not X, it's Twitter. Sorry, Elon. All right. Thank you for watching, and we'll see you next time on Men Need to Be Heard.
Thank you.